0JD28638. Also present in the court, Your Honor, are representing the state of Ohio's APA Brendan Mackin and APA Freddie Springfield. Representing the juvenile is attorney Michael Stepanek, the juvenile's father, Terry Kovabasich, and the juvenile. Also present, Your Honor, is the guardian ad litem, attorney James Barilla.
Thank you.
Your Honor, this time we are here for a probable cause phase of the Rule 30 bindover filed by the state of Ohio. My understanding is documents have been prepared, so I would defer to the state.
Thank you. Mr. Mackin?
Yes, Your Honor. Good morning.
Yes.
Juvenile counsel, Mr. Stepanek, and I have executed a journal entry that he's going to waive the probable cause hearing as it was a mandatory bindover.
Daniel, please stand. Do you understand what's going on today?
Yes.
What is your opinion of what's going on? Do you understand that we're waiving probable cause today? It's not an admission of guilt, nor are you waiving any right to have a trial in this matter. Do you understand that?
Yes.
Nor are you waiving any right to claim any defense or have any witnesses testify against you as far as cross-examination or to call your own witnesses. Do you understand that?
Yes.
It's merely indicating that at the time of the offense, you were 16 years of age or older. Is that correct?
Yes.
So how old are you now?
16.
And when was your birthday?
October 23rd, 1993.
So you were 16 at the time of the alleged offense, correct? Yes. It's also indicating that you were charged with what's called a Category 1 offense. Under the Ohio Revised Code, that would be a charge of murder. Do you understand that?
Yes.
Do you understand the charges that you have, in fact, been charged with? 2 counts of murder, 2 counts of felonious assault?
Yes.
Furthermore, there's a stipulation that Lorraine County is the proper venue, and stipulation that there is probable cause to bind this over. Do you understand that?
Yes.
So there will be no evidentiary hearing today to determine whether or not probable cause exists, or more likely than not that the offense occurred. Do you understand that?
Yes.
Furthermore, there will not be a background check as far as amenability is concerned because this is a mandatory bindover. In other words, I have lose jurisdiction today. I have no choice in that. Do you understand that?
Yes.
Which means this will be bound over to Lorraine County General Division, the adult court. Do you understand that?
Yes.
But needless to say that we are looking forward to defending against these charges. Mr. Kovabasich has no history of violent offenses. And the second purpose of bond is to make sure that he's going to appear at all future court proceedings. As we discussed a couple of weeks ago when we were here last time, despite the state's representation that Mr. Kovabasich was unavailable, because the state doesn't know where he's at doesn't mean he's unavailable. He was at his uncle's house in Avon Lake. Within an hour of being asked where he was at, I voluntarily turned him into the North Ridgeville Police Department. Mr. Kovabasich had no problem going. He understands that there's a process to this whole thing. This isn't going to be over anytime soon. But at 16 years old, charged with the murder, he said, I'm not going anywhere. Let's defend this thing. And I think that he should be given some credit and consideration for that. You know, the majority of the people in the courtroom here, to my understanding, are people that are here in support of Mr. Kovabasich. He's got a pretty decent network of family and friends that are willing to help him, assist him, make sure he's sticking around. I've had the opportunity to get a report from the detention home where he's been for the past couple of weeks. They said he's doing great. He's completing all of his homework, completing all of his assignments on time. He's been polite, cooperative. This kid isn't a problem kid. And I think that, keeping him in custody only is going to ensure that he doesn't get out. And if he doesn't get out, it means that schoolwork's interrupted. He's going to be unable to assist me in his own defense as well as I would like him to be able to. I don't think that there's a sufficient justification for an extremely high bond in this case. His family is of limited resources. I know that the state is going to request a very high bond because that's what the state does. I don't know that they have any insight into Mr. Kovabasich's personality that I myself don't have. And I think that I would ask for his release on a personal bond with his parents.
Well, when the court looks at the situation of bond, I have to look at several factors, as both counsel know, one of which is the nature of the charge, and one of which is what's high enough amount or low enough amount to guarantee that the defendant in this matter will, in fact, appear for court in his family background situation. I will note the limited amount of information that I have in this matter, and certainly bond can be taken up at any time in proceeding, especially once it's bound over. and then the new judge has that, whoever that judge may be. So at this set time, I'm going to set the bond at $500,000 cash or surety.